Good afternoon, everyone, and thank you for joining us for day 2 of Workers' Comp in Motion's educational webinar. For those of you that don't know who I am, my name is Carlos Luna, Vice President of Marketing for Risico, a Fresno-based TPA, managed care organization, and insurance service provider. On behalf of Workers' Comp in Motion, please accept our sincere apologies for the webinar platform juggling exercise, but we are extremely glad that you were able to join us in spite of the hiccup and are confident that you'll be glad that you did. Workers' Comp in Motion is developing a reputation for recruiting the industry's most respected and better looking, if I might say, thought leaders to provide premium education webinars to their constituents. Today's discussion is no exception. Workers' Comp in Motion presents the nuts and bolts of it, SB 1159 in a nutshell. Today's session will provide you with a legal analysis of the bill and newly enacted labor code, along with an employer's frontline perspective on the new COVID-based legislation. We want to take time to give a great big thank you to our sponsors for today's webinar. Without them, this would not be possible. So thank you to Siegel, Moreno, and Stettler, Institutes of Health, NewQuest, ClaimLogix, MacroPro, ProCare, GenX, Corvell, iRatings, Learning Services, Work Partners, Ember Court Reporters, Dental Works, California Orthopedic, and Optum. Please be advised that CEU credits will be provided to all attendees, and we will present raffle winners following the presentation. So be sure to stick around to see if you're a winner. By the way, if you get a moment throughout the day, make sure and give our sponsors some love online, visiting their websites, or taking a look at their social media pages and show them how much you care and how grateful you are for their sponsorship of this great event today. At this time, I want to pass the time over to Jen McCaw, your moderator for today, to introduce our panelists. Jen?
Thank you, Carlos, for that very kind introduction. We very much appreciate it. And we are so glad everybody is here with us today and that you're so flexible. Thank you so much. Today, we're going to discuss SB 1159. I'm sure we're all up to our ears with it. And I'm going to introduce our panelists. First is Tim Rose. Tim is a partner with Siegel, Moreno, and Stettler, and Tim runs the Northern California offices. Our second panelist is Tamara Cirillo. Tammy is the Director of Insurance Administration for Stater Brothers. Tammy is also a professor, so she'll be able to answer our questions very well. With that, we have a ton to cover. We're going to try to do it as clear as we can. And I'm going to turn it over now to Tim, who's going to start us off with the legal perspective of SB 1159. Tim?
Thank you, Jen. Hopefully everybody can hear me okay. It's a pleasure to be able to speak with each of you. I know that on my desk in particular, I have a lot of clients that have a ton of questions, and I've had an opportunity to speak about these legislative changes with them in bits and pieces, so hopefully this will provide a greater understanding of it as a whole. I'm going to be addressing the presumptions, and then Tammy's going to take over from an employer perspective. In reviewing the overview slide, I wanted to spend a couple of minutes to basically expand upon SB 1159 and AB 685 in a little bit greater detail before we jump right into the presumptions. And I also wanted to take an opportunity to kind of go back a little bit and to talk about where we were and why we are here now, why there are presumptions, and how it affects both employers and carriers and TPAs, both in a positive way, but also in a negative way. So it's no surprise the governor signed into law on September 17th of 2020, SB 1159 to expand workplace protections for workers in response to the COVID-19 pandemic that we're all living through. He also signed into law Assembly Bill 685, which will go into effect January 1st of next year, and then it will be in effect for the next 2 years. So in a nutshell, SB 1159 adds 3 new sections to the labor code, which you can see down below. 0.86, 0.87, and 0.88, all part of 3212. Each of those come with a presumption, and each of those codifies and addresses a different area of work or employee, or different type of employee, if you will. So what we have in a nutshell is 3 rebuttable presumptions if certain criteria are met. Now, the stated premise of the SB 1159 and AB 685 was to provide some guidance to employers and employees. It was designed to allow for recovery time at home, to help prevent the spread of COVID-19, which is a serious problem. And it was also used, at least according to the Department of Industrial Relations, as an encouragement, and I use air quotes for that, to comply with health directives and guidances to safely operate a business and to keep a business open or to allow it to reopen. Now, in addition to the presumption that was made with the original executive order that was signed by Gavin Newsom, which is codified under 3212.86, we now have 3212.87, which is pertinent to frontline healthcare workers and public safety workers in general, and then 3212.88, which I basically say kind of covers everybody else. So how are employers affected by this? Well, employers are generally affected due to the creation, go ahead and go back to the other slide, please. They're generally affected due to the creation of rebuttable presumptions. And again, it serves as an encouragement, again, I continue to use that as air quotes, to allow for compliance. On the plus side, it gives us a little bit more guidance as to what the employer needs to do in order to safely operate their business. And it also allows them an opportunity to potentially rebut somebody who's claimed that they have contracted COVID-19 at work. The Department of Industrial Relations also claims that it limits the risk to employers for being liable for claims if the infection did not occur at work, which is true. And it also tailors the presumptions to allow for greater understanding, if you will, and for a chance to be able to basically say yes or no, this injury occurred at work, and the presumption applies or it doesn't. So with that being said, let's talk a little bit about 685. Now, Tammy's going to be discussing this in a little bit more greater detail, but this amends the labor code in several areas to require employers to adhere to stricter occupational standards and safety rules. It also gives greater power to Cal OSHA to enforce those rules and regulations and to potentially levy fines. And again, what the Department of Industrial Relations has stated is that the overall goal is designed to promote greater safety and to provide greater insight by providing some specificity as to what individuals can report COVID-19 exposure, who should, and then what happens once it is reported in terms of the reporting requirements. What does the employer have to do? Who do they have to report it to? So forth and so on. So I guess I would go back to, why do we have presumptions in the first place? Quite frequently when we talk about presumptions in the workers' compensation arena, whether they are a part of this or they are a part of other rebuttable presumptions that currently exist, a lot of people seem to forget why they are in existence in the first place. So years ago, I read an interesting article. I don't recall who it was that wrote it, but he talked about the no-fault system that we presently exist in and how there is an equilibrium between the worker and the employer, and that equilibrium is not always balanced. And so therefore, there are rebuttable presumptions that are provided in order to tip the scales more in favor, although he was very honest and forthcoming and said it actually tips it a little bit in favor of the applicant. Now, we already have a liberal presumption when it comes to interpreting facts, evidence, case law, things of that nature already in favor of the applicant. And a rebuttable presumption basically adds on top of that. So that is something that I think that we need to continuously have in the back of our mind when we talk about these presumptions and what we can do to either confirm that it is something that we need to address, or if it is confirmation that, hey, this injury didn't occur at work, or we don't think it did, or we have evidence or defenses to try to defeat that rebuttable presumption. I would also say that presumptions exist to reduce the overall cost of litigation, and for the most part, that is correct. And then I would also say that it is also due to special interests. We do live in a political world, and there are certain groups that obviously want to protect their class of worker. Firefighters, police officers, correctional officers, those unions and types of individuals immediately come to mind when I think about that. I would also give a fair warning to both claims examiners and to employers. I've already had this conversation with a few of my clients. I wish to remind everybody that we are still in the middle of a pandemic, and the state of California has taken a very serious hit financially in terms of tax dollars, in terms of fees and costs and things like that. So I believe that when they say they can and will levy fines for failure to adhere to the reporting requirements and not determining appropriate presumptions and things like that, that they definitely do mean it, because we are in a time where the state of California, quite frankly, has a budget problem and they do need money. So I also believe that they will come down very hard on certain employers and on certain carriers and TPAs for failure to adhere to the reporting requirements and following of their guidelines. So that's just something I believe that we need to keep in the back of our minds whenever we are talking about dealing with COVID-19 cases. Next slide, please. So let's talk about the first presumption, which was codified as 3212.86, which codifies the prior executive order that was in existence back in March. If you remember, there was a sunset of the executive order, and this follow-up law and Senate bill and Assembly bill were designed to basically close that gap and then also to clarify a few things, because there were a lot of questions from the very beginning. So right off the bat, I've had a few of my clients have asked, well, I don't deal with police or fire or healthcare workers or anything like that, so why would I have to pay attention to this type of presumption? And the answer that I give them is that it establishes legislative intent. Whenever a dispute arises to a law or a regulation and we go to court over it, the court takes a look at not only the facts of the case, but they also take a look at what case law is presently in existence and what other types of labor code provisions or regulations are in existence. And a lot of the times new case law is established when they basically try to take a round peg into a square hole and say, well, while there's something not on point directly in our in our particular instance, we do have this other labor code provision or other statute or other regulation or other case law in some other area that seems to tell us what the legislature was intending. So even if you don't deal in a business that particularly addresses one presumption over another, it's good to still know and understand so that we can kind of see where the legislature was coming from and maybe even get some insight as to where they're going. So for the first presumption, it codifies the aforementioned executive order, and it basically creates a statutorily rebuttable presumption for individuals who perform work at the employer's direction outside of their home during this period. Now, a lot of people have questions as to, well, does it have to be at a particular job site? Does it have to be at a place where the employer has complete and total control? And the answer to that is no, because a lot of people that would fall under this particular section go to various places for their work outside. We have police officers that go to various scenes, whether it's a traffic stop or a crime. We have firefighters that go to different locations. We have correctional officers that sometimes have to transport individuals. We have healthcare workers that have to make house calls as part of their normal job, and they're not just simply sitting in an office. So therefore, while it's designed for somebody to work outside of the home, it's also at the employer's direction. Now, you have 30 days from the filing of a DWC-1 form in order to make a date of decision. This is a big deviant from the original 90 days for determining of a compensability injury that we normally see under the labor code. So it basically cuts it into a third, which means the employer has to timely report it, and the employer also has to provide all the tools necessary in order for the carrier or the TPA to complete their investigation. That means they have to make witnesses available. They have to have evidence in terms of the personnel file and other documents readily available. So it is a cohesive effort between the employer and the carrier and the TPA. Now, the first thing that's required is a positive test within 14 days of working at the employer's place of business. Now, again, this could be at a specific location, or it could be a location at the employer's directive based on the type of job that they have. If the test is completed timely, then COVID is presumed industrial. Now, what happens if they don't have a test that's completed timely? If there is a diagnosis from a medical doctor or holding physician or surgeon whose license is issued in the state of California by the medical board, that is one way that they can overcome that problem of not having that timely test. However, they also have to have a diagnosis confirmed with a positive test or an antivirus test within 30 days of the date that they make the formal diagnosis. One of the questions that I had received from an employer was, well, what happens if they get a test at, like, say, a drive-through location, such as a pharmacy or something to that effect? Those have popped up all over the country, and California is no exception. I initially was a little bit concerned because this code does not specify who has to conduct this test. It simply says if a test is completed timely. So I did a little bit of research, and based on what I have found with both my firm's research, some other firms' research, and in speaking with an epidemiologist, and then also speaking with a couple of individuals that work for various carriers that I represent, we believe that if the test is completed in the normal standards for the public health and safety as recommended by the state of California and then also the FDA, then it can be any test that is administered in those manners. Most of the testing will be done at a doctor's office or at a hospital or a facility, but the big thing to take away is that that test can be put together and administered by, say, like a drive-through or something to that effect, as long as it adheres to those standards. Now, what type of test are we talking about? I have found that the types of positive tests that are approved is the PCR test, which is the most common that we have seen throughout the state of California, or any other viral culture test that is approved by the FDA that has the same or higher sensitivity than the PCR test. So, long story short, there is a good chance that the test that somebody might bring to the employer falls within one of those two standards, and if it's completed within the 14 days, we have COVID presumed industrial. If there is not, we have a doctor or surgeon or somebody that is certified by the California Medical Board that makes the diagnosis, and they follow up with a positive test or an antivirus test within 30 days. That is the second way to get COVID presumed industrial. Now, let's talk a little bit about contraction. It can occur while performing duties at the employer's request or after working at the employer's place of business and at their direction. So again, going back to finding out what type of job this person does and if they're performing duties at a specific location or at a location that is requested to be worked at by the employer. A few other things, the MPN can be enforced. Once again, we have a 30-day decision on compensability. It's not 90, it is 30. And that's a very limited amount of time in order to complete a thorough investigation. So I would also point out that if the work did not occur outside the home or at the employer's direction, there's no presumption. If the work was not performed between March 19th of 2020 and July 5 of 2020, there is no presumption. So let's talk a little bit about defenses. Tammy will kind of jump into that a little bit more, but in the event that all of the facts as we've just discussed or turn out to be true, then the defendant is now placed with the burden of proving that COVID-19 is not contracted at work. How do we do that? We do that through investigation. We do that through finding out that the individual may have other high-risk activities where they could have contracted it, or we determine that the claim that it contracted at this particular work site or location could not have possibly occurred. Next slide, please. So moving on, we now have 3212.87, which again applies to firefighters, police, health facility workers, and home healthcare workers only. In my opinion, it's kind of a continuation of the prior code that we just discussed, but it is limited to these type of individuals. Now, the first requirement is that it is a healthcare facility worker. Now, what is a health facility? It provides really no great example. It simply says, hey, refer to this other section of the Health and Safety Code. So I did take an opportunity to review Section 1250 of the Health and Safety Code, and I will say that it is very generic. So under that Health and Safety Code, we have general acute cares or hospital, which means a general facility that provides inpatient services, 24-hour care, emergency room visits, someplace where they have anesthesia, where they perform surgeries, where you have labs, radiology, pharmacy, and dietary services. Now, again, that is very generic, but basically you could say that it's most hospitals. There is also the requirement that it could be an acute psychiatric hospital, which again provides 24-hour care, although it's on a psychiatric basis. This also includes skilled nursing facilities. It also makes mention of intermediate care facilities, which is a smaller facility that provides up to 24 hours of inpatient hospitalization. And then there's also living health facilities that could be temporary transition from, say, the hospital to somebody recovering from major surgery, or it could also include hospice care. Now, again, a lot of people that may be watching this will say, well, wait a minute, I don't have anybody that works, or I don't have any cases at somebody that works at one of these locations. The reason why it's important to still pay attention to this particular section is because 1250 of the Health and Safety Code is very general. It's very generic. And so is the legislature intending to limit the amount of locations that could possibly fall into this, or are they trying to keep it as broad and general as possible? I would say the latter. And so therefore, if there is later a dispute either in this section or another section, the legislative intent could be construed as, well, they meant to not specify it to only a set amount of locations. They provided some specificity, but they also left it pretty general. So, classes of workers. The workers range from very specific jobs to very general. The general is employees with direct patient care or custodial services in contact with COVID-19 who work at a health facility. Now, that could mean everybody from the physician who provides services to a nurse who assists, to somebody that works at a front desk when the person comes in, to the custodial staff who clean the general facility. It could also include other individuals that may work at that location. There's a specific mention of RNs, EMTs, and paramedics. That's pretty self-explanatory. Employees who provide care for a home health agency. Again, this is individuals that may actually make house calls. Some people that may work at one of those other facilities that is not a hospital that we've just discussed. Next, we get in-home support services outside of the employee's own home. So again, we have nurses. I have a few cases where I have nurses who make house calls. They make calls to residential facilities. They make calls to individuals where they're transitioning between either prison or juvenile detention and full release, or going into the jail or prison. Those locations could qualify for somebody that is making those in-person visits. And then others include, and this is where we get very general, employees of health facilities other than direct patient care. So this could be support staff. Again, this could be custodial staff. But the point is that it's pretty generic in terms of who could potentially qualify. Next slide, please. Okay. So now we have presumption number 3, which is what most people that will be on this seminar is really interested, because this kind of encompasses everybody else. Now, first and foremost, it's effective now until January of 2023. I have no idea if they are going to continue this after January of 2023, but to be honest with you, it wouldn't surprise me if they didn't. Now, it specifically states that this presumption applies for those not covered under 3212.86 and 3212.87. So again, this is why I believe that it, again, is everybody else. Now, when we're talking about reporting of an injury, we must first discuss, well, what is an outbreak? Because that is one of the requirements. So for example, number one, you got to have injury that occurs after September 6th of 2020 or later. Number two, a diagnosis alone does not trigger the presumption. Again, if you remember the prior code section of 0.86, a positive test or a diagnosis confirmed by a test is enough to trigger that. That is not the case here. You must have the diagnosis with a test and an injury after July 6th of 2020 in order to potentially trigger this presumption. And then we have this introduction of the definition of an outbreak. Okay, so what is an outbreak? This is where I think most employers and carriers have a lot of confusion. And this is where that cohesive effort that I mentioned before between employers and carriers and TPAs becomes incredibly important, because each of them has a set task that they are required to do. So an outbreak is classified as if during a 14-day calendar period, either of the following occurs. Number one, you have an employer with 100 or fewer employees at a specific work site and 4 of them test positive, or you have 100 or more employees at a specific work site and 4% of the employees test positive. Now, admittedly, when I first read this and I first started talking about it, I initially thought, well, I'm wondering if it's 100 employees in the entire company, or is it 100 employees at a particular location? And so I had to kind of redo my thinking and look up the specific information as to what qualifies as a specific work site, which we'll get to in just a minute. So number one, if the employee has less than employer has less than 5 employees, there is no presumption. So it's got to be 5 plus. This does not include individuals working from home, but that doesn't mean that they don't have to report any claims of COVID exposure, which Tammy will talk about in a little bit greater detail. If there is 5 more employees and there is an outbreak of work or outbreak at work, then COVID is presumed industrial. Now, again, you still have to have the positive test, you have to have the diagnosis, but if those 2 other factors come into play, then there is an industrial causation presumption. So one big difference about in terms of compensability, and I think that the reason why the legislature gave 45 days as opposed to 30 is to provide the employer and the carrier with a bit more time to gather information, because there is a lot of information that has to be put into this. It's not simply the employer saying, hey, we think an injury occurred, or they're reporting an injury. The carrier now has the onus of confirming if there is in fact a quote unquote outbreak. Next slide, please. Next slide, thank you. Okay, so let's talk about what constitutes an outbreak. Once again, you've got 5 employees. Number 2, you've got your date of injury of 7/6/20 or later. Number 3, it's a workplace that's not covered by 3212.87, which we've kind of discussed in some detail. So going back to the 4 or more employees test positive for COVID at a work site with 5 or 100 employees, or if it's 4% if they have 101 plus. Now, what is a specific place of employment? Specific place of employment can include the actual work site where you're at. It can include a building. It could include the employer's normal place of business. It can include a field where field workers work for agricultural purposes. There are a bunch of potential locations that are specified in this labor code provision, but I can also say that if it's not mentioned, there's guaranteed to be some litigation that's going to occur as to if this person was injured at what would be considered a specific place of employment. And although the code section provides quite a few potential locations for what could be classified as a specific place of employment, it doesn't say these are the only locations. It simply says these are some of the locations. We're giving you some examples. Now, the information that's collected from reporting the cases as indicated below is for the carrier or TPA to determine if there is an outbreak. This is why it is important for the employer to timely provide the information. Okay, we've got somebody that claims that they have contracted COVID-19. We have a positive test. Here's the information. Here is all the information as to where they worked within the last 14 days. And here is further information as to the number of employees we have at this particular location. All of that information needs to be provided in order for the carrier or the TPA to then collect the data and say, okay, we qualify for an outbreak, which triggers the presumption based on all of these other factors. Now, it is the determination of that outbreak that is used to determine if the presumption would apply. So obviously, it's really important to get that information out as quickly as possible. Next slide, please. So as I mentioned, it's very generic as to what this location could be. It could be a building, it could be a store, it could be a facility, it could even be an agricultural field where the employee performs work at the employer's direction. Now, it's important to note that although we still have to report COVID outbreaks, regardless of if they're at work or at home, a specific place of employment does not include the employee's home residence unless they are providing home health care services to another individual at the home or for a resident that may actually be residing in their home. So individuals that work from home, this would not normally qualify. Again, it's subject to the facts of the individual case. Now, let's just say that you have a confirmed outbreak, either based on the 4-person rule or the 4% rule. This triggers the presumption and applies to each specific place of employment only. So if you have an employer that has 20 different locations, the outbreak may be confined to one particular location only. Now, let's just say you have 2 or 3 locations in which there are, say, 20 people that work and 4 of them contract COVID and 4 of them report. Well, then it would apply for those 3 locations. But the point is that once you have a confirmed outbreak, it doesn't mean that it applies to every single location for the employer. It is limited to that specific place of employment only. Now, the basis for this limitation is it's designed, or defined, I should say, to encourage separation of work units by building, by store, by particular facility, by agricultural field, where the employer performs their duties. Now, this is where we kind of muddy the waters and get into the gray areas. Okay, well, say I have a facility with multiple buildings, and I have particular individuals that work in one department in this building, and I have particular individuals that work in another department in that building. Would it apply to all of those buildings, or does it apply to each individual? This is where we need to consider things like shared spaces for breaks, lunches, bathrooms, conference rooms. I know that I have certain employers where they actually work in entirely different locations, but there is one location where everybody gets together for training. It's in the basement of their main building. Now, interestingly enough, they own the building, and some of their employees only work on one floor. They only have access to one floor. They only have a break room on one floor. They can't take their key card and go anyplace else. I have some employees where they work in the same building, but they have access to every single floor. And then there are some employees that work off-site at different locations. But in the end, When they do training, they all get together in the conference room. And then I would also point out that with this same particular employer, the employees that are limited to certain floors have their own break rooms, but there are also other commonplace locations throughout the building where other employees get together for meetings, for lunches, for things like that. So that's a whole mess of potentials thrown about there. And what I have told them is that you need to look at the common areas. If somebody has access to a common area that another individual in another department or another building might have access to, then there is a very good chance, given the liberal interpretation, that if it is free reign to come and converse in those particular areas, that you may actually have to combine those two locations, even though they're technically separate. But what happens if you have the individuals that work on the one floor where that's all they have access to? They never go anyplace else. They don't even go to the training. They are confined to that one location. Well, for that particular floor, I have told them, I believe that everything that may occur within that location in terms of a COVID exposure or COVID outbreak would be limited to that one area. So then they would take the number of employees, and then they would multiply it by the number of individuals that work in that separate and distinct location. And that's how they separate out to determine if there is a COVID outbreak. I believe that there is going to be a ton of litigation over this. And I believe that the applicants bar will definitely try to expand it as much as possible. Somebody just asked an interesting question. I just happened to see it up in the corner, so I'll go ahead and answer it. What happens with restrooms? It's a good question. If you have access to restrooms on multiple floors, it is entirely possible that they could try to combine those, but that is subject to a liberal interpretation and subject to litigation. I personally believe that if you are limited to one particular building and one particular location, and it is not commonplace for somebody from another location to suddenly come down and use the restroom, then I think that you can generally limit the potential COVID exposure and outbreak to that one particular location. There are always going to be exceptions to the rules, and there's always going to be somebody, an applicant attorney, who's going to try to push the envelope. Generally, I say when you are looking at these common places, you take a liberal interpretation just to be on the safe side, but at the same time, you don't have to necessarily consider every potential possibility, regardless of how abstract it may or may not be. So it really does come down to the particular facts of the particular case and how you develop those and build on those. Those are good questions to ask. Now, kind of in closing, before we may jump into a couple of the questions, Jen, I don't know if we're going to do that now or not. All facts vary on a case-by-case basis. My job as an attorney is to sort out the facts and to determine what is relevant and what isn't relevant, and what could we potentially argue with this particular fact, and what should we just let go. There is going to be a lot of additional litigation that occurs because we're in the infancy stages, and there always is litigation. We just had a decision come down on TTD benefits as it pertains to COVID-19, but it took a couple of months to get to that point. So everything is on a case-by-case basis. And what I always encourage both employer and carrier and TPA alike is to take a look at those particular facts. I would apply a somewhat liberal standard to it, but at the same time, I would also be reasonable, especially when it comes to determining, you know, if it's a particular floor or a particular building that would qualify for that outbreak, or if we have to expand it over a greater area. Jen?
Thank you. And as you can imagine, the chat room is blowing up right now with questions. And so to be respectful of time, and Tammy's got a lot of things to cover as well, I want to jump into Tammy's presentation. And then Tammy, if you don't mind, as we go through it, we have some pertinent questions on specific topics that I'll ask both you and Tim as you approach some of those topics. And just so everybody knows, yes, we will provide a copy of the presentation. Just reach out to your whoever invited you to the webinar, and we'll get that to you straight away. And with that, I'm going to turn it over to Tammy.
Hello, everyone. So first, thanks to Jen and Tim for allowing me to be on your presentation today. They could have picked any employer, but they picked me. So good luck everybody out there with what I have to tell you. So we can get started. But Christy, you have a really great question, and I hate to jump in and answer this. But Christy, if your employee has been home since March and did not have an exposure from work, her wanting to take time off to recover from COVID is not work related. So unless she's entertaining other employees at home. So unless I don't understand this question, anybody who wants to take personal time to recover from an illness is totally fine. It doesn't seem like she would have had a work-related exposure whatsoever. So with that, we can go on to the next slide. Okay, so an employer has to do many things to try to keep our employees safe. So when March 19th came along and we all were faced with stay-at-home orders and just going into the pandemic, many of us thought it was going to be a 2-week period, a 4-week period, but here it is, October 22nd, and it doesn't look like there's anything in sight that's really going to change how we are currently living. So one of the things that happened with Stater Brothers Markets is we, of course, are a Southern California retail grocery chain. We became an essential employer. And never did I think that grocery workers were going to be essential employers, but we are. And we are here to actually serve communities, be able to help, with that whole distribution system of getting food to people. So it really kind of changed the entire dynamic. So to keep our employees safe, we have an obligation to serve, but with that, we have to also keep people safe. Many of the ways that we have done that is by creating what, per the CDC, all of us should be following, is social distancing, wearing face masks. I'm not wearing mine today, but I'm keeping you guys all safe. Of course, hand washing, increased cleanliness, plexiglass. There's many things that as an employer, you need to provide some safeguards for your employees. Sometimes temperature checks or even a very quick medical review of how am I feeling? Am I going to be a risk to others? So some of the things are non-occupational risk. We have many people who family members, cousins, aunts, brothers, husbands, friends who have contracted COVID-19. These are very important notes for you as the employer to keep for the future. Way back in March, April, May, as we've been trying to keep good notes of this information, sometimes we may have overlooked those things. But to be a benefit to your employer and to protect from future workers' comp claims, that type of data is very important for you to be collecting. The other thing is that you must have no contact within the last 14 days of somebody who has tested positive. If I have not come in contact with somebody in a 14-day period in the workplace, well, where did I get it from? So I'll give you an example. We did have one store site that had multiple people who ended up testing positive. None of these folks, and this was pre July 5th, so July 5th and backwards, they didn't ask for a workers' comp claim, but there was just too many persons at one site. And as we went through investigating, we were able to kind of pinpoint who was our ground zero person who may have infected other people. And of course, we're also able to get information of who in the family may have given different people the illness. So that is one way that you can protect your organization, is if somebody has not come in contact with somebody with COVID-19 within a 14-day period, that is also a defense that you can use as an employer. And of course, you really want to play it by ear. This is a pandemic. I don't think any of us really know our point of contact. We can guess, but you do have to pay very close attention as an employer if there is any type of illness or activity in a location. And for Stater Brothers Markets, we effectively have about 173 locations if you count our stores, our corporate campuses, and our warehouse and distribution systems. So there's a lot of activity going on. And with this, we went from having about a 17,000 employee population to having to move to a 19,000 employee population during this time just to be able to serve the public properly. So we did take on some, of course, more risk as we're adding more employees to help serve the public. Next slide, please. So temporary disability, it is one of those things that would be paid to the employee if they actually were out for an extended period of time. So why I say that is COVID-19, if you contract COVID-19, there's not a real treatment process for it. So many people will contract it. They may be ill. They get better in kind of a short period of time. It should be kind of a defined period of time. So with the retail grocery industry, and this is part of Governor Gavin Newsom's first order, is that we have what's called a COVID-19 supplemental fund. And that's a 14-day period that is paid for an employee, whether they have contracted COVID-19, whether they want to be able to care for family members or anything of that nature for 14 days. After that time period, we of course have our regular employer benefits, which according to Christy, I just want to let you know, like sick time, PTO time, etc., that is to be exhausted prior to moving into that TTD status. Now, the only saving grace that is good for most of us is that if COVID-19 runs its course, which should be kind of a defined short period, anywhere from 3 to 14 days, we probably shouldn't get into a TTD situation. Hopefully, that's the hope. Now, the bad part is if you are extending into that time period where you have the personal benefits that have been exhausted, you might be running into some type of catastrophic claim, unfortunately, because of the illness. One of the things to point out, though, is that once they are allowed to have TTD benefits, it would have to be certified every 15 days for the first 45 days. Again, COVID-19 is an illness. We're in a pandemic, but it really should be a short-term situation. But with the legislation that we see, I think most of us here today have to recognize that we have to be thinking long-term parameters of what all of this could mean in the future. So really, hopefully with each and every one of your employees, if you do have any type of benefit that has been mandated by the state, or you have a benefit that is mandated by the employer, and then you move into the employee's sick time or PTO, hopefully you will never have to get to the point of TTD benefits being administered to your employee. Now, it does have ed code and that would be for our fire, PD, etc. So again, I hope each of you don't get into that situation where it gets to TTD payments. I don't know if anybody who is on the call today can share an experience. As for Stater Brothers Markets at this time, because we have exhausted, of course, that first fund, which is the COVID-19 supplemental fund for grocery workers, and then sick time and PTO, we have been fortunate to this point to not have moved into the TTD cycle. Next slide, please. Death benefits. Now, death benefits, unfortunately, there are organizations that have been having people who pass away from COVID-19 and directly related to an industrial injury. With this, it would be covered as with any covered death benefit. Your dependents would, of course, have rights to that benefit. But I did run across something quite odd last week. We had an employee who was out for their supplemental time period, their COVID-19 supplemental time period, and they did expire during that time off of work. So as an employer, we took it upon ourselves to report it, doing what we thought would be the most correct thing to do. And we called the local, the county agency, and as I reported the incident, they didn't take any personal information or confirm. They just had let me know that if it truly was a COVID-19 death, that they would be notified and that we would be getting some procedures to do next. So I was a little taken aback by that, and that's just from the experience that we have had. I'm not sure if there's something else that employers out there have experienced, but for us, that is one that did take me back a little bit. The good thing is, unfortunately, if somebody does pass away, there are some benefits. First of all, there's a burial expense. This burial expense, everybody out there today, it's not a good time to have to bury somebody. At least there's some financial help there. With us, we have a high collective bargaining agreement working body, so there's a secondary burial expense. Of course, we have the other numbers down there as far as your dependents. There's a $250,000 payout if there's one, and $290,000 if there's more than one. So unfortunately, if anybody does pass away from COVID-19, it's such a terrible, terrible thing to happen. But under the work comp system, there's death benefits that would be available to the family of the poor person. Next slide, please. So all presumptions, regardless of the date of injury, are rebuttable. That means that we can research, confirm, do our due diligence to find out if it is or is not work-related. Many times, each of us are having contact with people multiple times a day, and it can happen in the workplace. It can happen when you're out to lunch. It can happen when you're with your family. And due diligence by the employer or by the adjuster when they're investigating the claim is going to help us determine if it is a rebuttable claim. So they do have the requirement of a positive test. And it must be done within a 14-day period from when they worked, okay, and not from the home. So I have told people that oftentimes you do have to have been at work within a 14-day period to actually even go into an accepted work comp claim for COVID-19, but you would also have to be at work within that 14-day period to collect any supplemental funds that are out there. So many industries, you have supplemental funds, but indeed, the first requirement is that within a 14-day period prior to taking any of those benefits, you must have been at work in some capacity. LC 4850, this does pertain to public servants. This is not something that we see or administer in the retail grocery, but this would be for police officers, fires, etc., that are covered with COVID-19 benefits after any original benefits have exhausted. The great news for all of us is the MPN is still enforceable for claims on delay and accepted injuries. So that's a good thing. But for many of you, your industrial clinics are not able to test or treat COVID-19. So that's something to think about. Yeah, see, I saw your look, Tim. That was a good look, because a lot of the industrial clinics, they're not set up to test. And they're not set up to treat. So we have to be really careful and understand as an employer that if you do have a partner in the medical arena, that is one of their specialties or something that they're focusing on right now, that you would want to funnel your employees to those facilities. Next slide.
Tammy, I'm just going to jump in there because this is pretty relevant to that last comment. Rebecca asked, since there is no actual treatment for COVID, what do you anticipate may be the responsibility of the carrier or the employer on these claims?
I'd like to say nothing, but so unfortunately, this is a very unprecedented time. And because this is such a fluid situation, what we said 30 days ago today is not the same. And there is no treatment. So I think that is a wonderful thing to point out. We cannot prevent it. We can try to do our best, right? By, like I said, the social distancing, face mask, higher intensity of cleaning, hand washing, and we can do everything possible, but we don't know if we will or will not contract COVID-19. So one of the things I tell people is very important is we just try to keep areas and people as healthy as possible. It is not something we can control. And anybody who has a classic COVID illness, it should be a defined time period, right? Like I said, anywhere from a 3 to 14-day period. It could go a little longer. I think that each of us should be more fearful, much, much more fearful of when somebody gets into that catastrophic state, because then there is treatment. And the treatment is not technically for COVID. The treatment is for any of these other things that go haywire connected to COVID. So, breathing. So I worry for the future, just on a side note, anybody listening, I worry for the future that 3 years from now, some applicant attorney is going to have a bunch of people with COPD claims going back to COVID-19. So as an employer, my best advice is allow the time off, and hopefully you have some type of fund set up. Once they reach that time, that it has expired, and if they want to use their own time, they can do that. And then you just really want to keep them connected and make them understand that there's not a real treatment, and that you're doing everything possible to protect them, and that it is as safe as possible to return back to the workplace. But yeah, there's no treatment. Okay, so safe harbor provisions. So this reporting to your TPA. So Cedric, gotta love you. Thank you guys for putting up with me and all the stuff I've been sending you. But really, I have to tell you, they've been very, very helpful. And like I said, each of us are approaching this in different ways, but hopefully pretty close to the same. But we're all trying to figure out, what do we do? So we do have until next week on the 27th to actually upload any data from that July 6th period through September 17th. I did try to get everything through September 30th, only because I actually had a carrier change effective 10/1. So I wanted to kind of clean up all of that data. So we do have that in currently to our TPA. So one of the things I want to caution employers out there, you really do need to take a look at any type of reporting of positive COVID-19 claims or COVID-19 issues to your TPA by next week. So one of the things as we move into the new regulations for January 1, 2021 is that there's some simple things that they ask for. They want to know the date of your positive test. So what day did I take my test? They want to know the date it was reported to the employer. So if I took my test on Monday, October 19th, that's the date that I, as the employee, would report to my employer. But if I didn't tell my employer until today, which is October 22nd, that's the second thing that's very important. The date I took my test and the date that the employer was notified. Because I technically have 3 days to notify my TPA, but I only have 24 hours to notify the location. So notifying the location is one of the big changes. It's a good tweak, because what I have noticed is that most employers have been doing what I call proximity notification. So proximity notification, when you have somebody positive in the workplace, is really looking at someone who has dwelled for about 10 minutes or more with another associate who would have been positive. And you would check during that course of that workday, you do some tracking, and those are the folks that normally have been notified. That has been our practice. And as I have reviewed other employers, proximity notification is normally what I have seen. They're not notifying the entire location. So that is one of the big shifts. An entire location must be notified within a 24-hour period. You also must notify any collective bargaining agreements, which could act as representatives for your employee body. So that's a 24 hours. So while I have 3 days to get my information to my TPA, I only have 24 hours to make sure that I'm hitting all the proper thresholds of notifications to employees. And I think it is important that you're very transparent with your employees, because the worst thing that I have seen, and we all have made good moves, and we've all made mistakes as employers as we're going through this process, is that even when somebody doesn't truly have um, uh, an exposure, they still want to know that somebody in that location has had a positive COVID-19 test. So you may not have worked with them in the past 10 to 15 days. You may never work with them. You don't dwell in the same area. But I just think that in general, people want to know. So again, the big things to report is the date of the positive test, the date that it was reported to the employer. We are required, so going back to something said earlier by Tim, is we do have to know how many people, like within a 45-day rolling period, what is the max amount of people who work at that location. So it could be 100. 100 is a nice round number. So with 100, you would report your highest number within that 45-day period. And then, of course, we're looking at that 14-day window of who may have been exposed. And we really do just want to make sure that people are prepared, notified, and I hope that COVID-19 is over every single day. I hope that it comes sooner than later. But based on our legislation that we're discussing today, the anticipation is that these new statutes will not sunset until January 1, 2023. So there are some predictions, obviously, by that time frame that we are going to be dealing with COVID-19 for a while. So one of the other things, too, from a reporting perspective, is you don't have to provide a claim for you. You just want to make sure you're getting all of this data to your third-party administrator to help you with it. And you know what? God love you, third-party administrator, because I would hate to have to do this all on my own. And I know that most of you employers out there, it's hard enough as it is. So we're all in this and learning it together. So, and of course, none of us are going to be perfect. Next slide, please. Okay, so after September 17th, the employer must report any positive COVID-19s within 3 days. See, 3 days for the TPA, 24 hours for the store site. It is actually very important. It has been simple. I don't know if any of you have been connecting with your third-party administrators' reporting sites. Of course, we've been in that practice for the last couple of weeks and trying to make sure that we understand what we're doing. Practice makes perfect. So if any of you have not technically connected with any of these uploading systems, my best advice is that you get back with your team today, tomorrow, and start to try to understand what does the reporting system look like and what will I do. Now, one of the things for the notification of your sites, your locations for all of your employees is that since it has to be up in 24 hours, they want you to communicate in the fashion that you usually and customarily communicate with your employees. So if you normally send out information to your employees via email, if you send out notifications via written letters, so snail mail, or if you do postings for your organization, you need to follow what is the most systematic way that you deliver messaging. So a great example is, so we have already thought out our plan for January 1. And because we are an organization that communicates almost exclusively with the larger body of employees through posted IOCs and messaging, we're looking to have preset messaging that would cover the COVID-19 requirements and make them site-specific for an occurrence, along with the other things that you're required to provide, which is what is your cleaning and sanitation, your protocols when you are dealing with a COVID-19 positive test. So that is something that's very, very important. And I think that while all of us right now are trying to figure out how to get this reporting done correctly, we also need to figure out what will be our messaging to our employees, and how will we get it to them in a digestible manner. Each of us also has an obligation not to create panic. And if anything out there right now, if you are actually working, or you have an employment body that is working with the public or actually has to go on site, each of us already understands how detrimental it could be if you start to lose the active working body because of being panicked by COVID-19. And I will tell you, we are going in cycles of up and down. Even in my own division, my own department, we had outbreak. So, and we are a facility that we're in our administration, the human resources building. And while there is multiple departments in the building, we had reached 3, because we were advised by some of our local health departments that was our point of reporting. So 3 to 5 has always been our measure, even prior to the new statutes coming down. But once you have reached any type of critical mass, it is very important that we report. We clean, and clean some more. So that's very important for anybody. Next slide, please. Okay, so reporting requirements. Ooh, this is the bad stuff. If you do not report, you are going to be penalized. And I 100% agree with the panelists today. When you're not generating revenue because different things are at a standstill, you are going to have to pay these penalties. We have a higher obligation right now anyways. If anybody has employees working, if you have any type of employees working, whatever body you are, you do have a higher obligation to not only your employees, but you have an obligation to do the right thing. And the right thing is about doing a good job reporting. We're never going to get 100% past this if we all don't work together. We have seen some other fellow retail grocery industry folks come up with quite a few penalties, and we are just working hard every single day for that not to happen. The other thing is just a reminder, it does not require that you give someone a DWC-1 to file a report or a claim, but you do have to report. A lot of the reporting, just from the legal perspective of reporting, is not even asking for personal identifying information, right? We are just really trying to make sure that you are providing the information of positive tests and to locations. I'm not a super genius, but this tells me that what we're really trying to make sure is that we're watching any hotspots that can create outbreaks, or what are we doing in certain areas. Again, after this is all over, I'm not sure where things will shake out, but there's definitely a lot of more reporting that is coming to us, especially under the work-related perspective. Again, for us, it took us quite a journey to actually get most of this data, the COVID-19 perspective, into the right areas. So people look at this generationally from when COVID-19 started to where it's now at. Our tracking didn't even start in the workers' comp arena. The tracking when we originally started doing COVID-19 was in our retail ops and in our EEO division and a little bit of human resources. But as you saw the twist and the change of kind of what COVID-19 was going to be when Gavin Newsom came out with his ordinance on 4/20, 2020, then what you saw is that there was definitely a shift of moving things to becoming more industrially related. So for us, I'm thankful that we've been following this evolution, and now are able to really understand what is expected to us as an employer, and just making sure that we're getting everything in. Again, you don't need a claim form. You don't even need any private information on the employee. You need the date of the positive test, the date it was reported to you, and then, of course, the location where they stated that they were working at the time. Next slide. Okay, so AB 685, it does go in effect on January 1, 2020. And this is when you're really going to have to just report that data. We've already been talking about it. So we have to notify local health departments and public agencies within 48 hours when we have an outbreak. So an outbreak, we'll go back to that number, which is now a little more specific. I've seen it anywhere from 3 to 5 persons is what you should consider an outbreak based on what the population of the area is. So you must do that as of January 1, 2021. Now, I know most of you have already probably been doing it because for us here at Stater Brothers, we have already been doing it. In fact, LA County, because they're pretty proactive, they really want to have regular interval. If anybody has been a positive COVID-19, we'll actually have calls with them and talk about where the location was, where the exposure was. So your health departments are going to vary from area to area, but we do have now 48 hours to notify them. So the outbreak, 3 or more, I would definitely make sure that those get reported. And then you also want to gather as much data as you can. Data, data, data. Did I get it from my brother? Did I get it from my sister? I went to a wedding and 5 people have it. Those are the kind of things that are going to help you in that rebuttal process. I actually have a coordinator for leave management, and we specifically have this huge spreadsheet that has all this specific data that we know one day we will use. We're not using it yet, but we know one day it will have to be used. So again, it says a CDPH will be required to create a COVID-19 reporting platform by the time that this goes into effect on January 1, 2021. Next slide. All right, back to you, Jen.
Well, thank you. I know you said you're not a super genius, but you are a super genius. Tim, you're a genius. You're right there. You're right there. But both of you, thank you so much. We have a ton of questions in our question box, and I know we're getting very, very close to our time, and we do have some housekeeping to do. I just wanted to ask maybe 3 questions that I think are really pertinent and important. One of the questions is, does an employer have to report those cases of positive COVID if they're temporary workers, or are they required to report it to the temp agencies? I know we have Solar Turbines is one of our clients, and we have a lot of employers that use temp agencies. Tammy, what's your thoughts on that?
So my thoughts are, because the exposure would be at your work site, so that employee does have to tell the temp agency, and the temp agency has to do their due diligence. But the exposure is at your work site, so I would report it because it has to go into the numbers per location to determine if it's an outbreak.
Tim?
I would also add, I would agree with that, and I would also add that it doesn't specify if it's a temp employee or a part-time employee. It simply says employee. So it's better to be safe than sorry. So yes, I would certainly do that, but I would also make sure that they report it to their temp agency.
Okay, thank you for that. Doug has a very good question too. Positive test for an employee that was traveling out of state for work. Would that apply though to their outbreak, his numbers to a local outbreak?
The answer would be if it was in a 14-day period that he was in the same location, it would be attributable to the outbreak. So that number would count.
So let me actually read his question verbatim. Will an employee that learns that they are positive while traveling for work out of state count towards the facility if they worked in the facility within 14 days of being diagnosed COVID positive?
They were not. If they were not, they would not be counted in the location.
But if
okay, they were. Yeah, they were.
If they were, they would be counted. So it's that 14-day defined period. So if they had set foot in the location during any of that 14-day period, you would have to count that.
Okay. Yeah. Okay. And the last one, and again, we are happy to address any questions everybody has that we couldn't get to. Please just email your person that invited you, and we will get to them. The last question, very quickly, and again, this is Eugene. Leave it to Eugene to come up with the doozy. What about family members that are exposed from an employee who is diagnosed positive with COVID and it is industrial? Is the employer on the hook for those family members?
I would say that that is subject to a lot of debate. I have read a couple of very interesting articles in the last few days that discusses negligence and potential civil suits as a result of exposure in the workplace. And it was actually from a firm that was trying to encourage people to try to, hey, contact us. We may actually be able to file a lawsuit for you. I believe that the exposure exists, but I also believe that there is a reasonableness standard that would apply to a regular negligence claim. And what did the employer do or not do? And what are the other facts of the circumstances? So that's completely open to interpretation. I believe that there will be attempts, but I also believe that there are a lot of potential strong defenses, primarily based on what the employer does in order to try to minimize the exposure.
Okay. Agreed, Tammy?
So I agree, but so the biggest thing, and this may be a popular statement or an unpopular statement. Unfortunately for all of us, we are in the middle of a COVID-19 pandemic. But by definition alone, something that we can't control is not something that insurance would cover, right? Because if it's, how many of us have used active nature or active God to deny other type of insurance claims? So I'm just kind of give you, you like that one, right? So technically, just by true definition, COVID-19 should not be something that's having should have such a negative impact on all of us. I mean, it's already bad enough that it is affecting us from a health perspective. I'm 100% with Tim that people will try to find a way to make, whether it's employers, governments, or any other entities responsible for any illness, ailments, things that occur to them. Again, my hope for everybody is that, COVID-19, if you do contract it, if you do know anybody who does have it, that it's unfortunate you have it, but hopefully you have, that systemic time period, the 3 to 14 days, and that you get better and you move on. I think that all of us really have to be so worried about a catastrophic event and what that could mean to the employee, the organization, and hopefully, more than anything, I hope that we get past COVID-19 as quick as possible. But I do promise you guys, you're going to be paying out some money somewhere. So I'm not sure what they're going to come up with, but they will.
Yeah, I agreed. Absolutely. Well, thank you both. That was very insightful. And I know it takes a lot of energy and time to discuss this new COVID legislation. Very, very helpful. Thank you both. Really appreciate you, Tammy. Tim, thank you so much also for your energy and everything that you did. I also, Work Comp in Motion wants to send out a very special thank you to Carlos Luna with Risco for providing this last minute support for us. He jumped in, he made this the presentation possible. He did a lot of overnight work. We're indebted to you, Carlos. Thank you so much for doing that. And we've got just a few more items, some housekeeping. Carlos is going to let you know about our raffle winners and your CEUs. And with that, I'm going to pass it over to Carlos.
Well, Jen, thanks so much for your very kind words. I put out a post on LinkedIn and said, anything for my workers' comp in motion tribe. I truly mean that. It's my pleasure to jump in and help out. I want to echo your sentiment and thank our panelists today. And of course, you, Jen, for such a wonderful job with the presentation. I particularly want to thank Tammy for that wonderful shout out for all TPAs. Sometimes it's a thankless job, I got to tell you. By the way, a link of the recording for today's webinar is going to be distributed to all attendees, hopefully within the next couple of days. So be on the lookout for that in your inbox. As a reminder, you will also receive your CEU credit certificates within the next 24 to 48 hours. And now the moment we've all been waiting for. It's raffle time. Folks, I don't know if you can give me a virtual drum roll or not, but are you ready? Here we go. Ta-da!
Yay.
Congratulations, everyone.
Yeah, so if you see your name on the list, you'll be contacted by the corresponding organization to make arrangements on how you can claim your prize and receive it as well. And, you know, on behalf of our panel, all of the wonderful sponsors that are part of this wonderful association, Workers' Comp in Motion, thank you for joining today's presentation. The nuts and bolts of it, SB 1159 in a nutshell. I really hope you have a wonderful rest of your day. Thanks so much, and I hope that you found today's webinar insightful and beneficial. Thank you. Have a wonderful afternoon.
Take care.
Bye,
Bye.
everyone.